Next up on This Week in Law, we once again have a staffer from the EFF joining us to help unpack PRISM and Verizon, the NSA, Edward Snowden, everything that's been going on in the last week. That's Hanny Fakori. We also have Travis Crabtree joining us from eMedia Law. We're going to go deep on the NSA and what's been going on there. We're going to look at some kid privacy issues too. And with the funniest copyright story that we saw this week and some great resources and tips for you too. All very topical next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 215, recorded June 14, 2013. The least untruthful show ever. This episode of This Week in Law is brought to you by ShareFile by Citrix. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a free 30-day trial, go to sharefile.com, click the radio microphone, and enter Twill. Hi there, I'm Denise Howell, and you're joining us for This Week in Law. We could not be more excited to be here with you this week of all weeks, where in the aftermath of the revelations about the NSA surveillance that's been going on, there's something new out every day, and they all have legal ramifications. We're going to try and unpack it with you here today, and we've got a great panel of folks to do just that. Joining us from the Electronic Frontier Foundation is Hanny Fakori. Hello, Hanny.
Hey, how are you? Thanks for having me.
It's wonderful to have you. Thanks so much for taking the time to join us and help us get our heads around some of what's going on, and also update us on what's going on at EFF, which is one of the ground zero places right now for paying attention to understanding and advocacy about the news that you've all been seeing in your headlines. Also joining us from eMedia Law is Travis Crabtree. Hello, Travis.
Hello, and thanks for having me.
Great to have you back on the show. Very interesting stuff that you've been paying attention to as well. Also joining us from Chicago, Illinois, and the Info Law Group is Evan Brown. Hello, Evan.
Hi, Denise. Happy Friday. Looking forward to our conversation. Should be a good one.
It should be. Great to see you, as always. All right. Since there's a lot of focus on what sort of privacy protections we're enjoying in the United States these days, let's start there. All right, so if you watched the show last week, you'll remember that we talked about various lawsuits that have been pending over the last several years related to the FISA court and its activities and whether those activities are constitutional. And a big hurdle in those lawsuits has been that the parties bringing them did not have standing. In fact, there was a Supreme Court case throwing out such a suit earlier this year. Well, guess what? The ACLU has filed another such lawsuit now in the wake of everything that's unfolded over the last week. And the ACLU itself happens to be a Verizon customer. So I don't think they're going to have the standing issue anymore, in addition to the fact that they could readily add lots of other people who are Verizon customers to pursue constitutional challenges to the order that came out last week. So this is good news, Hanny, isn't it?
It's definitely good news, especially for those of us who have been trying to challenge the government's, surveillance of internet communications and telephone calls and whatnot. So, earlier this year, the Supreme Court threw out one of these lawsuits, another ACLU lawsuit in a case called Clapper versus Amnesty International. And, the big issue there was whether there was standing, and the Supreme Court found that the standing there was too speculative to count. And because of the revelation of these NSA programs, both the order to Verizon ordering it to disclose records of telephony metadata, I'm sure I said that wrong, as well as the PRISM program, I think the issue of standing has just become less of an obstacle or barrier for these lawsuits to go forward.
Right. So if we can finally get past this standing hurdle, we can get the question of the actual activities and their constitutionality in front of a court under the Fourth Amendment. What the ACLU says about its current case just filed, which is ACLU versus Clapper, is that the program goes far beyond even the permissive limits set by the Patriot Act and represents a gross infringement of the freedom of association and the right to privacy. So hopefully we can finally get a court considering those kinds of considerations, as redundant as that might sound. Evan, what is your take on getting past the standing hurdle and getting into the substance?
Well, it's good, obviously, good that we can, that we're at a point where we can start getting into the substance now, because for me, that was the part that was most troubling. The reason that there wasn't standing was because all this stuff was secret. There wasn't enough information for plaintiffs to articulate how they had been injured, which was the design of the program, really, for it to be secretive like that. It was a real bootstrapping problem, or a catch-22 or chicken and the egg problem. I always have a hard time picking the appropriate metaphor when trying to, or choosing among those probably equally appropriate metaphors for that. So it's inevitable that we would get to this point, I suppose, because more information is going to come to light through whatever means, whether it be through the government choosing for whatever reason to disclose more information, whether it comes through other vectors like leaks or other means of this stuff being disclosed. So there's no doubt it's a good thing, because this is an incredibly important privacy issue, different than I think the one that affects most of us, with the NSA vacuuming up call information about like we were talking about either right when the show started or right before the show started, talking about metadata about this stuff. A little bit different than that, because this deals, I understand, with the actual communications of phone calls. So in a certain sense, the privacy interests are greater in this sort of situation than the NSA situation that affects us all. But at the same time, this also affects foreign communications, so that may offset some of the privacy interests that we have here. But in any event, there's nothing bad about this, these practices and this, what's going on here being more public and tried, adjudicated in a public way.
All right, so we will definitely have to keep our eyes on that. It may not be the only case that flows out of this. Hanny, do you know if the ACLU case is the only one I've seen so far? Is there anything else pending as a direct result of the Guardian and Washington Post revelations?
There is another case that was filed in D.C. That raised many of the same kind of issues that the ACLU raised in their case. And I think there's likely to be more cases to come as a result. But I wanted to talk very briefly about one thing that you mentioned about the standing as an obstacle. There's another obstacle that has been raised in some of these cases, and that's the state secrets privilege, the idea that the government doesn't have to necessarily disclose publicly or even to opposing parties or in a court proceeding some of the surveillance tactics it's using, because it may compromise security and whatnot. And one of the nice things that we've been able to kind of learn is we've been able to actually see the specific types of orders and evidence that have otherwise been kept secret for a long time. And so that helps to shed some light. And hopefully, like you said, we can actually get courts to start thinking about the legality of these practices, both under the Fourth Amendment and under FISA and the Patriot Act as well.
Hanny, the EFF recently had a small victory along those lines. It's not as revelatory as the leaks that were made to the Post and the Guardian. But on the procedural front, the EFF won a motion in front of the Foreign Intelligence Surveillance Court, aka FISC, that said that certain of these opinions, that the court's rules itself were not a barrier to disclosing the opinions. So the court itself hasn't released any opinions, but it has taken away one roadblock. Am I right?
Yeah, absolutely. And what happened in that case was there had been a lot of FOIA litigation over whether these opinions that are issued by the FISC could be made, released through FOIA. And what the Department of Justice had said in some of the FOIA litigation cases was that the FISC prohibits us from disclosing that information. And so we filed a motion with the FISC asking for clarification. And what basically the FISC said is, no, our rules don't prohibit someone like the EFF or the ACLU to having these opinions be adjudicated through the FOIA process. And so basically what that means is a litigant can go through the FOIA process and try to get these opinions. That doesn't mean the court's going to ultimately agree that we should get those opinions. But what they're saying is there's nothing in the FISC rules in and of themselves that prohibit us from using FOIA as a channel to get those things. So what that means is that our FOIA suit on the issue is still alive, and we could litigate that issue in front of the district court that's handling the FOIA case.
Right. And just in case anybody out there doesn't know what Hanny's referring to when he says FOIA, that's the Freedom of Information Act that makes public private government documents under certain circumstances.
What was really interesting about that is that in the past, when I believe it was the ACLU had filed a lawsuit through FOIA a number of years ago saying, we want these opinions, and I'm sorry, that they had filed a suit in front of the FISC saying we want these opinions, and the DOJ there said, no, you have to use FOIA. So then when we used FOIA, they said, no, the FISC prohibits us from disclosing it. So it was this like kind of, never-ending circle. Like in front of the district court, they're saying, no, you have to go to FISC. And then in front of FISC, they're saying, no, you have to go through DOJ. So therefore the answer is nobody gets it ever. And right. The FISC said, no, we're not, no, that's not how it works. You can litigate this through FOIA. So that's a very important victory. And hopefully now that our FOIA case can continue on, hopefully we can actually get some of that information made public through the FOIA process. So.
And the motion the EFF brought is specifically geared at orders where something that the NSA has requested has been held to be unconstitutional. So where the FISC has not acted as a rubber stamp, but has prevented something the NSA has wanted to do. It would be very interesting to see those.
Right, and specifically, there's basically a number of senators, specifically Senator Wyden of Oregon and Senator Udall of Colorado, had kind of publicly said, both on the Senate floor and in press releases, that if the public had known how the FISC was interpreting portions of FISA, they would be very worried and troubled about it. And ultimately, it turns out that the FISC had issued a lengthy 80-plus page opinion finding that some foreign surveillance under FISA and the Patriot Act had been unconstitutional. And so our FOIA is specifically trying to get that opinion out. And naturally, the government has been a bit reticent to have that information turned out publicly. So this is kind of, we have to make little baby steps in getting this, information brought to light, but we've at least cleared the hurdle, which is that we can actually adjudicate this under FOIA, and hopefully we can, again, get the actual opinion or some part of the opinion.
Denise, may I let me play devil's advocate, if I may?
Please.
I joked with my friends that I was going to come into this discussion with somebody from the EFF. It's like arguing religion with a priest, and I'm just not equipped. I may go to service, but it doesn't mean I know nearly as much as the priest about this. But it does seem to me that, yes, it's good we're having these conversations about where the line should be, but I do have some concerns about having a open trial on exactly what's going on. The EFF's blog, which I have been reading in the past before this broke out, and they do an excellent job, had questions on there that they want answered either through a congressional hearing or through a litigation process. And yes, those questions would be fascinating to know, but I think the terrorists or people trying to do harm to us want to know too. And I just don't know, I'm struggling myself. I'm generally, First Amendment, shine the light, all that's good, open records, but somewhere there's got to be a line. And yeah, it's good to know these things, and there's some good questions that need to be asked. I'm just not exactly sure where that line is.
I think that's a really valid concern, and I think it's important to, we don't disagree that there is a line to be drawn. I think, but the problem is the line that the government has currently drawn is you get nothing about anything, period. And that's not an acceptable line to us. I mean, I think we're open to exploring ways in which, pure legal interpretations of the law shouldn't be kept secret, period. They don't have to reveal specific methods. They don't have to reveal specific forms of, specific instances of individuals they've surveyed, but at the same time, they have to disclose enough of what's going on so we can be sure that the law is being followed. And again, there's always this tendency to kind of fall into this false dichotomy that we either have to have absolute secrecy or absolute privacy. And I think the reality is we can have both of those things. It's just that we have to actually demand both of those things, and we have to ensure that our representatives and our courts and our executive branch and law enforcement are, cognizant of the fact that they have to explain, to some extent what they're doing to the public in order for us to trust them when they say that these programs work or that they are keeping us safer. We just don't have any way of knowing that, and we don't have any way of knowing whether it's coming at the expense of civil liberties abuses, and that's really what the problem is.
Right. I have never heard an NSA apologist say that it would mean the terrorists win if we are merely made aware of the contours and the considerations and the issues that this secret rubber stamp court will consider when it is determining whether or not somebody should have information collected about them. The simple analogy would be to compare it to a much less toxic situation, because it gets so freighted and so tainted when we start talking about terrorism and Al-Qaeda and all this stuff. If we just look at ordinary criminal procedure, I mean, we're entitled to know generally what the police standards are when they're going to investigate or interrogate somebody for a simple crime, like a drug transaction or white collar crime or something like that. That doesn't mean that law enforcement efforts are completely undermined if we don't know the process and how it works. Yes, if there's particular information, specific intelligence that is made available, that can certainly stymie an investigation, but that is nothing, that is not compromising, the way of compromising in that situation is nothing like just telling us how it works, which would not compromise the integrity of the whole process and would not make us more vulnerable. And I would be, I would welcome any kind of NSA apologist to say how, merely letting us know what the procedures are and how our constitutional interests are being safeguarded, how that would mean the terrorists win.
I think that's a great point. And I would add one other thing, and that is, most of the, I hate to kind of, I don't know the right way to say this, but I'm going to just try, and hopefully this is going to sound not so terrible. But basically, like, the terrorists aren't that stupid. Like, they're not sitting around saying, hey, you know what, we probably shouldn't use Yahoo Mail to send messages. Part of the whole point of the program is that they are using means to hide what they're doing, and they're using secret communication channels, or they're using dummy email accounts and using code and stuff. So it's not like they're sitting around saying, oh my God, all that stuff we've been saying in that Facebook message board on those wall posts on our Al-Qaeda Facebook page have been monitored by the feds. Like, well, of course they have been. So, I think we have to have a more sophisticated understanding of what the real threat is. And I think we have to, again, there's a way where we can balance the security and the privacy so that we can have both of those things without having to say it's all or nothing. And I think, again, the way to do that is to be upfront with the public, with how these programs are being used, the law you're relying on, how you're interpreting certain legal terms, and revealing, what the court that's issuing these opinions is saying and what their legal rationale is, and also saying, hey, you know what? In instances where we've screwed up and we've violated the law, here's how we did that, and here's what we're doing to rectify that in the future.
Travis, this seems like a good time to mention that a group of senators from both sides of the aisle have introduced a bill to declassify those FISA court opinions, and they're trying to address the security concerns that you raise. And here's what they have to say. They say that their legislation would accommodate national security concerns if the Attorney General determines that a court opinion cannot be declassified without undermining national security interests. Then the Attorney General can declassify a summary of that opinion instead. But if the Attorney General determines that even a summary of the opinion would undermine national security, the Attorney General would be required to provide a report to Congress describing the process to be implemented to declassify FISA court opinions, including an estimate of the number of opinions that will be declassified and the number that are expected to be withheld because of national security concerns. So it seems like they have some layers in place there where the Attorney General has some leeway to work with the government agencies in question and, at least provide, at the very minimum, some numbers about what will be declassified and what won't. Does that help allay your concerns?
Yeah, I mean, certainly there's got to be a balancing approach to this, and I think it can be done. And again, I'm not an NSA apologist. As a typical lawyer, I can take either side of an argument and sort of advocate that side. And so, but one of the interesting parts is, I certainly want to know what types of information are you getting about me? I mean, are you reading my emails to my wife about the grocery list? And then, how you do it, and I think we all agree, how they do it and certain things like that should stay secret. But this is one of those interesting, and again, I'm not a pro-government, they're always right type of guy, but this is one of those where, you've got to believe that our representative folks in Congress have been given some information, more than obviously we have, in private by the executive branch about what's going on. This is not one of those issues where there's a huge lobby necessarily tainting their decisions, tainting Congress's decisions about what to do because of some lobbying or financial interest or something out there. This is one of those issues, in my opinion anyway, where Congress is looking at what is in the best interest of the country and trying to balance that line between what's public and what's not. So I'm not sitting here saying that we just have to trust them and don't go any further than that. But I do think there are some balances there in place. And I do agree with everyone. There should be more information than we know now. I'm not exactly sure where that line is, and I'd be interested to see where that comes out.
Hanny, what do you think about this bill that's being proposed? The Senate Majority Whip, Dick Durbin, doesn't have a whole lot of optimism, as the Hill reports, that this would go anywhere. What's the take from EFF?
Well, I think it's a good first step. We've been asking for greater transparency about what the FISC is doing and how, what its opinions say. So I think this is a good first step. I'm worried that what's going to happen is, let's say this bill were to pass, I'm worried that the NSA or the AG or DOJ or whoever would just say, well, everything is classified, and we'd have some of the same problems. But at least it's a step in the right direction. But I want to go to a point that Travis mentioned, which is about Congress being informed of what's going on and kind of having our best interests in mind. And I certainly don't necessarily disagree with that all the time. But I think one of the big problems with this whole program is that, given what's been kind of the reaction amongst many people on the Hill in the last 10 days or so, the sense is that perhaps Congress wasn't really all that informed of what's going on, or if it was a small subset of Congress. And I think even more problematic is the reality. I mean, there's no other way to say it, is that the executive branch lied to Congress about what exactly it was doing, and specifically, there's been a lot of attention paid to the Director of National Intelligence, Clapper, when he testified in front of Congress, and Senator Wyden asked him whether the NSA was collecting information on U.S. citizens and collecting any information from U.S. citizens, and Clapper said, no, not wittingly, and we now know that's just simply not true. And if we're in a situation where security officials are not being truthful to Congress in hearings, even after Wyden gave him the question the day before and gave him a chance to clarify his answer afterwards in private, if they're not even being upfront with our elected representatives who are supposed to have our interest in mind, then how can we trust that they're, not only that they're being honest with us, but that they're doing the right thing or they're following the law? And so I think that's again, that's part of the problem with having secret courts that interpret the law secretly. and interpret the secret law secretly. And that's just not the way our democracy was established.
Right, and the secret law is almost written in secret words, right? Wasn't that your piece that you wrote, Henny, about the word collected and the semantics of that? I mean, and how it has just a different meaning to the NSA and Clapper than it does to everybody else.
Absolutely.
Yep.
I mean, it was one of my colleagues who wrote it, but to the NSA, collection means when you actually review something rather than when you actually take it, and that's just not the way the word is used in everyday common language. But under NSA's word games, that's how they've interpreted it. So, we need more oversight and clarity about what exactly is going on and how they're interpreting the law and the decisions that have interpreted the law so that we can understand what exactly is going on.
The piece Evan's referring to is in our discussion points. If you want to pull it up and everything else that we're discussing today, you can go to delicious.com/thisweekinlaw/215. And this particular article is by Kurt Opsahl, who's also been on the show before. The NSA's word games explained how the government deceived Congress in the debate over surveillance powers. Henny, is there any, aside from just giving us the overview of the article, what really jumped out at you from this?
Well, again, I mean, I think the fact that, first of all, like I said, the way they define words in ways that's stretch the bounds of credibility, and we mentioned collect, and I won't repeat it, but that's one great example of that. And then again, the fact that Clapper went in front of Congress and wasn't completely honest, and then even after the fact, after all of the leaks by the Guardian and the Washington Post, went on one of the Sunday morning talk shows and even admitted that he was too cute by half, which, is kind of funny. But also, I mean, here is the head of our national intelligence admitting on national TV that he wasn't completely forthright with Congress on a matter of surveilling and effectively spying on, all Americans in the United States. And to laugh about it and joke about it and to say it's too cute by half, I think is almost an insult, really, to the fact that we have a set of laws that have to be established, that if our executive branch doesn't respect the legislative branch and doesn't keeping them informed and playing these word games and not being truthful, then, how are we supposed to function as a democracy where there can be a debate and we can make decisions about how much security we want at the expense of how much privacy? But we can't have those real debates if no one is being forthright or honest or open to the public.
What was it that he said? Because it's really classic. He said that he did it in the least untruthful manner. Isn't that right? Something like that?
Right.
I mean,
exactly.
that's up there with the internet as a series of tubes. If you ask me, that ought to go into kind of like the mockery Hall of Fame. And, I mean, it just gets me. I call it Clintonian. What it all depends on what the meaning of the word is, stuff like that. That's just BS. It's unadulterated BS. And, if you look up good faith in Black's Law Dictionary or wherever, you see, I don't know if Black's Law Dictionary says that, but you Google it. And good faith is honesty in fact. And, if you're going to be splitting hairs like this when you're talking in a forum like, at a Senate hearing, that is not honesty in fact. That is not good faith. And that's just that's a violation of the law as far as I see it.
Well, I agree. We wouldn't want our kids to talk to us that way, right? And we wouldn't expect our colleagues to use these, semantics. I mean, he Clapper himself said semantics, and that our executive branch is using this type of deception to Congress is very troublesome, and it calls into serious doubt the truthfulness of other things that they've said. Fool me once, that's my bad, but fool me twice, that's on you. And it's a lot of that is, I mean, that's exactly the problem. How can we trust what they're saying about the program, about the limits in place of the program, if not only are they being deceptive to Congress? I mean, after the fact, in the last few days, where there have been both Senate and House hearings on some of this, there's contradictions between what, for example, the head of the FBI, Mueller, testified yesterday, and some of what he said was contradicted by what the head of the NSA, General Alexander, said. So, I mean, how can we really trust or rely anything that's being said? We have to, really seriously scrutinize what's going on so we can figure out what actually is going on.
Well, Evan, you've put up a couple of tweets referring to the Nixon impeachment proceedings. Do you think that things might go in that direction?
Well, I don't want to talk about this too much because I really don't care for the Obama administration all that much for a lot of other reasons. I'm mostly angry at the Obama administration about the IRS stuff. So if you look at Article 2.2 of the impeachment papers, you'll see, well, actually, it's the Article 2.2 that talks about electronic surveillance that Nixon was alleged and probably did actually do, for no national security purpose, no law enforcement purpose in violation of our constitutional rights. So it's entertaining to read the Nixon impeachment papers and substitute, Richard Milhouse with Barack Hussein. So, but, like I say, I don't want to go down and turn this into an appearance on Fox News lambasting the Obama administration. But I do just think that this is the most corrupt executive branch we've had in recent history. He's a product of corrupt Chicago, political machine. His ideologies are so far off base of what all of us see. I honestly think that he doesn't really care for America all that much. He's steeped in the ideals of Bill Ayers, Jeremiah Wright. So here I am in my Fox News interview nonetheless. But it's just I think that this whole NSA stuff is indicative of a much deeper problem. And, I kind of daydream, read the impeachment articles against Nixon and substitute, Barack Obama's name.
All right. Well, this seems like a good place to drop in an MCLE passphrase for the show. Let's go ahead and make it Fox News. And remind people that if they are listening to the show for continuing legal education or education credit in some other profession, we put these passphrases in the show. So in case, various states have different requirements to show that you actually listened to something like this way you have some proof that you did. There's just a random passphrase or two, and there are going to be two hidden in the show. The first one's going to be Fox News. So we'll do that. And I want to get into talking about the substance of the Fourth Amendment, maybe a bit about Edward Snowden, and also about the technology companies and their responses. So let's go there as soon as we thank our sponsor for this episode of This Week in Law, which is ShareFile by Citrix. In business, we are constantly collaborating with coworkers and clients, sharing files like contracts, spreadsheets, presentations, and it's essential that these important files be kept safe, secure, and under your control. Paying a lot of attention to those issues on these last couple of episodes. ShareFile by Citrix is really going to help with that because it's an easy-to-use business solution that allows you to exchange files quickly and securely. What it's perfect for is sending large files, for example. So where you might otherwise be worried about an email bounce back, or if you just want to make sure that the file got there and got read, you want to make sure that it's easy for the recipient to collaborate on the work with you. ShareFile is perfect for all of those concerns. I use it in my own law practice as an extranet. It's very customizable, so I can have a presence on ShareFile that my clients are very familiar with. They know that my letterhead looks like that, my website looks like that, and they know it's me that they're dealing with just visually. And I know, and they know too, should they care to get the whole spiel on ShareFile, that everything that we share is confidential and secure, to the extent that the FISC court hasn't ordered otherwise. So we're very big fans of this technology here at the Twit Network. I've had my account for a few years now, and it's really, really useful in my business. So I want you to try it too. If you're worried about the size of files that you have to send, if you do large video or anything even that incorporates large images or clips of video, it eliminates the problem of needing to wonder, gee, is that really going to get there? Are they really going to be able to open it? It's sent as a secure link that can be accessed by the people you authorize. It syncs automatically, so you and your team always have the most updated materials, which is really important too if you have documents in progress. And it's a great remote access technology. You can access ShareFile from anywhere, your laptop, your tablet, your smartphone, while you're working on the go. So do give it a try. You can sign up today and receive a 30-day absolutely free trial with no obligation. To do that, go to sharefile.com, click on the microphone at the top of the homepage, and enter TWIL, T-W-I-L. Remember, visit sharefile.com and type in TWIL. Thanks so much, ShareFile, for your ongoing support of This Week in Law. All right, so I don't know if anybody caught the Colbert Report on Tuesday, but that was one of the highlights of my viewing of the week on TV. Stephen Colbert had Jeffrey Rosen, the head of the National Constitution Center, on, who, like so many very serious people who go on the Colbert Show, had a very serious conversation with someone being a comedian, and yet it still was informative and enlightening. His comment that stuck with me is that under the Fourth Amendment, you cannot have general searches on an ongoing daily basis without particular information that is linked to a particular crime. So that's really the crux of what we're trying to get to here with these orders and the information gathering that's been going on. If folks saw Nilay Patel on Twit last week, he's very interested in whether the Washington Post is correct, as it reported in its original story, that as you're typing in a search query, that might actually be viewable by the NSA as it's being typed in if you are under investigation. So nobody really knows the answer to that question, but the answer to that question will involve, okay, so what is a reasonable search under the Fourth Amendment? And that is the substantive issue that we're trying to get, or hopeful of getting in front of a court to take a look at. Hanny, do you have a whole lot of doubt that something as extensive as has been reported would violate the Fourth Amendment?
I have no doubt at all. And I think it's important to kind of distinguish between the two different programs a little bit, because while I don't have any doubt, it's a little bit trickier when you actually look at the law and what the courts have said. And so, you know, the Verizon order that requires all metadata surrounding a phone call to be disclosed to the NSA, that is kind of one aspect of this. And that in that instance, you know, there's old Supreme Court case law from the 1970s that says people don't have a reasonable expectation of privacy under the Fourth Amendment in information they turn over to third parties. And in the case that the specific Supreme Court case, it's called Smith versus Maryland, that was a case that dealt with pen registers, or basically the phone numbers that you dial. So a pen register is this piece of technology that the law enforcement can get a phone company to install on their switching stations. And basically it keeps a log of which phone numbers you dial. And basically in that case, the Supreme Court said you don't have a Fourth Amendment reasonable expectation of privacy in the numbers you dial because you're telling the phone company, hey, connect me to this phone call. And so, you know, that is the case that to this day in 2013 has been used by the DOJ and by local law enforcement to say that when it comes to information turned over to third parties, you don't have a Fourth Amendment right, which really means that they don't need to necessarily get a search warrant to get that information. Now, we believe that that is just no longer the case in an age where people turn stuff over to third parties all the time. So, you know, we're doing this this podcast on Skype. So Skype now has a record of where I'm sitting, where Denise is sitting, you know, how long we talked for, when we talked, what IP addresses we connected from. And that's going on all over this country in myriad numbers of ways, to the extent that it creates all this information about who we communicate with, how long we communicate, what are we communicating about. This is not what the Supreme Court had in mind in the 1970s when it was talking about the specific phone number you dialed. It couldn't have not have envisioned the internet and this explosion in global communications. So to the extent that there's going to be an argument by senators trying to defend the program or NSA officials trying to defend the program, the Verizon program, that there's no expectation of privacy in that data, I would say that there is an expectation of privacy, and that it's even heightened when you're talking about this bulk collection of this data or this aggregated data that can reveal a whole lot about you. Now, when it comes to the PRISM program, I think there's an even stronger case about a reasonable expectation of privacy, because courts have been slowly recognizing that there is an expectation of privacy in communications, meaning emails or Facebook postings, the actual content of those messages, regardless of the fact that they're sent from Google to Yahoo servers, that you still have an expectation of privacy in that information. And so if you think about it, it makes a lot of sense. You write a letter and you put it in the mail. You don't expect the post office to open your letter. They may handle your letter and see that you're sending it from San Francisco to Las Vegas, for example, but they're not going to, think that every letter is read by the post office. Well, it should be no different when it comes to emails or electronic communications either.
We had a question, Hanny, kind of along those lines from Dan from the East Coast, who's wondering about this third-party issue and corporations considered persons under the law. If you are giving your private information to an entity that is considered a person under the law, then isn't that person entitled to some kind of Fourth Amendment protection as well? I'm not a constitutional scholar, and I'm thinking that there are probably cases that have said that, yes, even though corporations are persons under the law, they're not entitled to the same kind of privacy protection as individuals. Am I on the right track there?
Well, that's an interesting point. And I think the thing, when it comes to the Fourth Amendment is supposed to protect people and not places. And there's always a threshold issue in Fourth Amendment cases, and that is the issue of standing. So if I put information on Google Drive, for example, or Dropbox, okay? Let's say I keep some work files. I'm writing a brief and I put that file on cloud storage. Who owns that file? Is it my file or is it Google's file, right? What Smith versus Maryland said was, when you turn that information over to the third party, it becomes the third party's information to do whatever they want with. And there's another case also from the Supreme Court in the 1970s called United States versus Miller, which dealt with bank records, records of transactions. So you go to the bank, you deposit a check, the bank keeps a record of that interaction you had with the bank. Well, whose record is that? And the Supreme Court in that case said the records belong to the business. And because they belong to the business, you don't have a Fourth Amendment protection against challenging the search of those records. And the same thing in Smith with the phone numbers. But I think we're entering a phase where, files that you keep on Dropbox I don't think most people would agree that those are now Dropbox's files. Dropbox is keeping those files for you. In the same way that if you put some jewelry in a safe deposit box, you're not giving the jewelry to the bank. You're just asking the bank to hold that information for you. So I would argue that what that ultimately means is that your Fourth Amendment protection in those files is still exists, notwithstanding the fact that you've turned it over to someone else. And given the way the internet is used today to facilitate communication, to store documents and pictures and movies and whatever, I think that's especially true.
Okay, well, here's the take from Padre SJ, who's joining us in IRC for the show. He's the host of Twiat This Week in Enterprise Tech on the Twit Network here, and he's playing devil's advocate this time and says the internet is a public resource. It's a public place. It's outdoors. Anything that you put into a network that travels across the publicly facing internet should not be and can't reasonably be considered to be private. Now, he doesn't really hold that view, he clarifies, but can understand those who do. What do you think about that?
I think there's a difference between information that anybody can publicly access. If I go to the Twit website to watch this live stream, that everything is there. It's there. I don't have a right to control that. If I'm sitting here and I'm doing a podcast and there's a live web stream of it and I say something stupid, well, shame on me. But that doesn't necessarily mean that everything that travels through the web is open for public inspection. My email is not open for public inspection. I have to put a username and a password to log into it, and I expect that, no one is going to read my email. The same with my Facebook page. Now, I may reveal some information to some people in some ways. I may have friends on Facebook and I share a picture with them, but that doesn't necessarily mean I also open them up to seeing my private communication with my wife about the grocery list. So I think we have to take a more nuanced, realistic approach to how people perceive the web. Now, what I'll say is the government has certainly tried to argue that when it comes to technology and the internet and the way, the internet is really not owned by us, right? I don't own the wire network or the Wi-Fi that I'm using to communicate or connect to the internet. I don't own the Gmail email inbox. They're trying to say that therefore diminishes my privacy rights. But, that's not necessarily the case.
Travis, you want to weigh in on these Fourth Amendment considerations?
Yeah, I do, and I'm like you. I don't do criminal law. I'm not a scholar on the Fourth Amendment, but one of the things that kind of going too far the other way to suggest that this information belongs to the individual. I in my private civil cases have used subpoena powers, which there is some protection from the courts that I can be abusive and they'll stop it if that's the case, but I go to Google, I go to YouTube, I go to Google, I go to Yahoo and ask for these records, and I do it straight from those entities. And even if it's a personal email, I will get access to that. Again, there are those protections that the judge in a civil case can go to. And the lockbox analogy, that's the person who put the jewelry in the lockbox. It's their property, but if I get a judgment, I can garnish that bank, and I don't care that it's the individual's property. So it's sort of one of these, again, balancing lines. And Fourth Amendment issues on the what we've been calling the Verizon issue, the metadata. To me, you hear sort of the Chicken Little aspect of this story is, well, they're going to know that you've been calling up the prostitute and come out with this information and embarrass you with it, or find out that you've been talking to a drug dealer and convict you of a crime in that way. We're not talking admissibility at this point, because right now we're talking about the mere collection of it and whether or not that violates the Fourth Amendment. I think the admissibility issues when and if this information is ever used in an actual trial would be another issue. But it's kind of like giving tax advice or patent advice at this point. I think I'm stepping outside of my expertise, and
right.
It's better to know when to just stop and get out of the way than to keep going sometimes.
Absolutely. Evan, what's your take on all of the speculation about the technology company denials of participating in the program? There are all kinds of theories floating around out there about, their own semantics and what it means when they say direct access and there isn't any. Obviously, it's all speculation at this point, but what's your gut feeling?
Sure. Well, there's got to be something going on, some kind of wiggling that they're doing, some kind of straining ordinary meaning of terms, not unlike what the government is doing in this. Google in particular. I mean, it's got so much information, and it's come out and said that there's certainly no direct access, and it's not like a Dropbox, small d, not the the company Dropbox. It's not like that, but it's got to be some kind of hybrid. And I think, was it Michael Arrington on Uncrunched tried to connect some dots. That's the figurative language he was using on how this is actually done. And, it got a little too convoluted for me to follow precisely where he was connecting those dots. But it's something that's quite nuanced. And, clearly these companies are not without blame in this, because they're have to be complicit in some respect, whether it's because they're following the law or what have you. They're not without some responsibility. I guess we could at least say that in all of this happening. Twitter's role in this is interesting. It's of course conspicuous by its absence on this list of awesome 9 companies who were disclosed in the Ed Snowden PowerPoint slide that talked about the timing of the release of all this stuff. But then again, Twitter doesn't necessarily have as much information. As much rich information about stuff as what some of these other companies would do. So let's hope Twitter keeps up fighting the good fight. AMAC and his sensibilities and others within Twitter hopefully will continue to be as resistant as reasonably possible in the face of the or the absolutely necessary corporate, what's the right word to say? I could say conspiracy in all this stuff, or at least the corporate cooperation with the government is probably the most neutral way of saying it.
Yeah, I'm glad you mentioned that Arrington piece, because he picks out on something that was reported by David Kravitz over at Threat Level at Wired that was picked up on by him. And that is this aspect of how the FISA law works. Here's what Kravitz reported on it. He said, the legislation does not require the government to identify the target or facility to be monitored. It can begin surveillance a week before making the request to the secret court, and the surveillance can continue during the appeals process if, in a rare case, the spy court rejects the surveillance application. So where Mike went with this is that the government doesn't even have to get an order. It can be getting access for a week. Then the order can be, and it can serve, it can make the request to the technology companies before it even gets its order. It can get all the information that it needs, and then things can conclude without an order even being issued. So if I'm interpreting Mike right here, he's saying this gives the tech companies some plausible deniability because they're not even responding to FISA court orders here. They're simply working within this week buffer zone, this week-long buffer zone. Hanny, do you think he's way off base here?
It's not entirely clear how these programs actually work. And so, when it comes to plausible deniability, I'm just not entirely sure. But I think the point remains that we are entering a world where there's going to be a demand for government access to this type of information. And I would actually argue that Twitter actually does have quite a bit of useful information for law enforcement. And in fact, in the last few years, we've seen a growing increase in the number of requests by law enforcement to Twitter for user data. And one of the reasons for that is that while Twitter may not have the same breadth of information that Google may have, the clientele of Twitter, or the people who tend to use it more, are generally more politically active. They're younger. They're more outspoken about their beliefs, and so that's a big selling point in terms of getting law enforcement access to that information. And so, the reality is that the companies are being approached all the time. But if we have laws that say, the government can get access to this data with minimal showings, they can get sweeping, broad, blanket disclosure orders authorizing them to turn over all this information, then, we don't really have any privacy safeguards in place. And that's not the type of, world that we've created for ourselves, or country we've created for ourselves, rather. And it's not the one that we deserve.
All right. Well, it would be nice to have a lot more transparency around all this. The only reason we have the degree of transparency we have now is Edward Snowden, who made his identity public last Sunday. Not to shift the story away from the substance to the leaker here, but I just wondered if any of you wanted to talk about his prospects at this point, what may happen next with him, and whether you think he will successfully continue to stay abroad and not be tried. Evan?
I think he's in a lot of trouble. I think he'll probably get chased down. I think it'd be pretty hard for him to avoid the authorities on this forever. That's a completely separate issue from the, evaluating whether what he did was the quote unquote right thing to do. I guess I'm not going to call him a traitor. I'm not going to call him a hero. But there's a Democratic congressman from Connecticut, Jim Himes, who was on C-SPAN yesterday, and I think he articulated it very well. And I would just adopt what Representative Himes said about Snowden, is that it would be wonderful. What would really make Snowden's efforts more perfect? I'm paraphrasing. I'm not using the exact nomenclature that Himes used, because he articulated it much more better than I did, that I'm doing. But if it would be great if Snowden would just kind of go through all of this and accept the responsibility for what he has done. Instead, he's being evasive. Maybe he's running off to China. That's kind of in bad form. If he was truly in the tradition of Martin Luther King Jr. in civil disobedience, or Mahatma Gandhi, or Thoreau. The representative didn't use Thoreau as an example, but he did invoke Gandhi and Martin Luther King Jr. Then stand up and face the consequences. Come and bear the consequences for what has happened here. So that just seems to be the way that like pure civil disobedience should be done. And adding more to this. I have he's a friend of mine. He's a veteran of the first Gulf War. He was a captain in the Air Force. One of the most patriotic people that I know, who represents what ideals America, the ideals that what America means to me are most embodied in kind of his attributes. And he said that he probably would have done the same thing that Ed Snowden did. If he had been in that position and had those, had access to that information, because of the seriousness of the offense that's being committed against us in our privacy. So it's by no means a simple calculus, and it really weighs or brings up some very weighty issues and kind of pits them right against one another. The idea of our civil liberties versus patriotism, and is the government right, and does the government always have our best interests in mind when it's looking out and trying to protect us? I think it's hard to say, but I think at the end of the day, Snowden's going to be in trouble.
Yeah, Hanny, any thoughts on him in particular?
Well, the one thing that comes to my mind is that we wouldn't need people to leak information if the government was more open and forthright about what it was doing in the first place. There wouldn't need to be people like Snowden disclosing classified documents if the government was forthright. So I think that's the first thing that comes to my mind. And then the second thing is that, while it's certainly a compelling story, and it's fun kind of getting caught up in the dynamics of it and how he held the Rubik's Cube to meet Greenwald in Hong Kong. That's all like out of a spy novel, but we don't want to lose sight of the real story. And the real story is the fact of this surveillance. And so I think we have to be really careful when we're, in the media especially, needs to be very careful about not losing the forest from the trees. That the idea that ultimately, he did all this because there's a large surveillance, dragnet or sweep or whatever you want to call it that is existing, likely outside of the boundaries of the law. And it's, if the government was more forthright, we wouldn't need people like Snowden to put his life on the line.
Well, you're right. It is like a spy novel, and there are various theories out there. John Dvorak on Twit last week posited that perhaps it was, a CIA, NSA kind of political maneuver, one getting back at the other. So yeah, there's just who knows, where all this goes or what sort of fun the script writers will have jumping off from this scenario. Back to Stephen Colbert, he decided at the end of his interview with Jeffrey Rosen that the NSA is actually protecting us with all this from further terrorist threats because, as he said, they hate us for our freedoms. The less freedom we have, the less likely they are to attack us. So, this is actually all for the best.
Probably, that's such a. Colbert is great, and he said it so funny. But the reality is that there's a common misconception about that. This idea that if we've got nothing to hide, we have nothing to fear. There's no problem. And I think when if we're talking about the future of our Fourth Amendment, we have to stay away from that type of thinking, because the Fourth Amendment, the legal test for whether there's a search under the Fourth Amendment, is whether there's a subjective expectation of privacy that society would treat as reasonable. And, we kind of shorthand that to a reasonable expectation of privacy. But it's necessarily, and that determination necessarily hinges on on whether people would treat certain types of behavior as private or not private. And, if we start thinking that, well, I've got nothing to hide, so what, then, what's going to end up happening is that Fourth Amendment line is going to keep getting pushed and pushed and pushed to the point where there will be no more privacy. And so we have to abandon that type of thinking because it's dangerous as a legal matter. And then, obviously, a lot of people have written in the last week that it's, everyone does have something to hide. I'm on the show, but I'm not going to tell people my social security number or how much money is in my bank account or my home address, right? Everybody has things that they want to keep from other people or that they selectively reveal to some people. And we shouldn't just forget that reality when we talk about what goes on the internet, because it's the same thing there.
Yeah, there was a really good Slate piece on that. It's not coming up for me right at this moment, but it's in our discussion points. It's titled, If You're Okay with Surveillance Because You Think You Have Nothing to Hide, Think Again. So for more on that, oh, here it is. It's finally coming up. It's by Dana Boyd, actually, over on Slate. So for more on that, see Dana. Travis, I'm going to give you the last word or thoughts on PRISM and Verizon before we move on to some other stories.
Thank you. Regarding Mr. Snowden, one of the interesting aspects from a trial lawyer's perspective is, he first came out and revealed the order. That was sort of, dropping a bomb and started this discussion, which has been good. And then he kind of seems like he's been pushing the envelope and pushing the envelope and pushing it just a little bit more each time with comments about what he can do, what he had access to do, and what the government was doing. From a trial lawyer's perspective, you tell the witnesses, if we don't need these kind of things, don't go out on a ledge unless you have to. And it seems to me that some of the things that he's been saying are sort of getting to the point where they are ruining his credibility. You don't go out on the ledge on these points that aren't important, because if you do, you lose credibility, and they won't remember, or they won't believe you on the important thing. So as you hear more about some of these allegations that he's making, it's just interesting from a trial lawyer's perspective about some of the other things he's saying, and what is that going to do about the credibility, his credibility on the things that have already been revealed. And obviously the court order, no one's denied that that's an actual court order and in place. So you can't discredit him, at least on that aspect. But as he goes further and further down that, down the diving board, at what point is he going to jump off?
All right, excellent question there. Hanny, I think we could use some good news around this juncture of the show. Why don't you tell us about what the Massachusetts Supreme Court thinks about warrantless GPS surveillance?
So yes, there is actually some good news in privacy world, and that is in a really short but sweet opinion. The Massachusetts Supreme Judicial Court, their state high court, basically ruled that people have an expectation of privacy to be free from warrantless GPS surveillance. And, it's a case called Commonwealth versus Rousseau. The EFF, we filed an amicus brief in that case, as well as the ACLU of Massachusetts and a couple of other organizations. And what's really fascinating is last year, the U.S. Supreme Court ruled in United States versus Jones that the installation of a GPS device was a search under the Fourth Amendment because it was a physical intrusion on private property for the purpose of obtaining information. And that was a very old test that the Supreme Court in the 20s and 30s had used in deciding Fourth Amendment cases, but basically kind of strayed away from that test in 1967 in its decision in Katz, which then created this reasonable expectation of privacy test. And after the Katz decision came out in 67, court has always kind of traditionally thought of Fourth Amendment cases by looking at this reasonable expectation of privacy issue. In Jones last year, the Supreme Court revived this kind of property-based test for the Fourth Amendment and basically said it still exists. So does the Katz test. You got to think about both of them. And Jones decided it under trespass or this physical intrusion, and didn't really decide the issue under the Katz test. So what the Massachusetts court was deciding was whether under the Katz test, people have an expectation of privacy to be free from GPS surveillance. And it specifically was thinking about whether the passenger in the car in addition to the driver of the car who owned the car, had an expectation of privacy to be free from GPS surveillance. And what the Massachusetts court said was that both the driver and the passenger had an expectation of privacy to be free from GPS surveillance. So this is one of the first court opinions to rule that under this expectation of privacy test that you have a right to be free from GPS surveillance. And really, it's not that it's specific to GPS surveillance, but really it's about long-term monitoring of your location. And so Massachusetts joins a number of other courts that have reached the same conclusion, including New York State and South Dakota. And hopefully there are cases in the federal courts where this is being considered, although they are kind of punting as much as possible on the location issue. To the extent that the cases involve GPS surveillance. So this was definitely a good step in the right direction in that regard.
Right, and it's important to note that what the court found here was not that GPS surveillance was unconstitutional, but just get a warrant.
Exactly, and it goes back to that security privacy thing. It's never a matter of saying the police can't do this type of surveillance or use this type of evidence gathering tool. It's just a matter of how do they go about using it. And what Massachusetts said was that police are absolutely entitled to use it, but they have to get a search warrant to do it. And that's what we've long argued. We've never said they can't use these types of mechanisms at all. It's just that they should have to get a search warrant in order to do it.
Evan, good decision here?
Yes. And you know what? There is just so much that is wrapped up into this that's important to the conversation we've been having all along. And it's our concern, and it's our fear, and it's our legitimate disdain for the government being omniscient, knowing everything about us and what we do. I think it's really interesting. You hear people talking about how, let me tee this up. With the NSA and what it's doing with this, vacuuming up of a bunch of records and creating the Colbert, as Colbert described it, a haystack from which to pull a needle. Doing that is justified under the Smith versus Maryland decision from 1979 that we were talking about earlier, which says that you don't have a reasonable expectation of privacy if the information has been disclosed to a third party, like the phone company. You know that the phone company has the phone number that you're dialing, so you give up your subjective expectation of privacy. Therefore, it's not a search when the government comes and gets that. The same rationale could go to this idea that you're out there, as Padre S.J. was talking about in IRC, it's outside. There's this ordinary understanding that we have that it's not, I don't have the right of privacy as to where I am, at any particular moment on the public street. But it becomes different when we have this huge paradigmatic shift occasioned by the technology. And I'm first in line to say that there shouldn't be any such thing as internet exceptionalism, and we shouldn't craft laws that apply just because high technology is involved. But if you look at a long view of history and see how technology actually changes the very fabric of our society and the way that we interact, the way we communicate, the information that we display and can be gathered about us, I do think that at a certain point it does require some change. And that reconsideration, in one incarnation of that, is a reconsideration of this third-party doctrine, this idea of you give up your expectation of privacy under the Fourth Amendment if that information is with a third party, if it's out there, if it's outside, if it's with someone else. And Justice Sotomayor does a really good job in her concurrence in the Jones case that Henny was talking about there, saying, it could be time to reconsider this because of the way we are now. And so with this GPS issue, the Supreme Court has told it, the U.S. Supreme Court has told us that it's a property interest that's implicated. It's a Fourth Amendment property interest. The fastening of the GPS device onto the car is what made that a Fourth Amendment violation. But that, we've got to reconsider the Fourth Amendment in this broader context of this new subjective expectation of privacy. And if we can make that shift, and if we can change the law in that way and make it so that it's clear that you do have a Fourth Amendment expectation of privacy, even if it's out there somewhere else, e.g. in the cloud, then that is going to be the constitutional basis by which we can put a stop to this surveillance, whether it be by the NSA or whether it be by the cops thinking that you're selling cocaine or driving around the state committing arsons.
Right. Well, that's the crux of it, isn't it? That we're talking about different kinds of law enforcement getting different kinds of treatment. If you're talking about police officers in the state of Massachusetts, they're going to be held to one standard, but when national security is at stake, apparently another one applies. And not only do you not have a property privacy interest, but that property privacy interest that you might have in your handheld GPS device, enabled device like your phone, just goes out the window because you can, under appropriate circumstances, all that data is accessible. Hanny, do you think that there's a way of harmonizing any of that?
Well, I wish there was, and I'm hopeful there is. I think you really hit the nail on the head when you said that there's kind of a different standard that applies when it comes to national security investigations. And I mean, look, we can talk for better, whether that's a smart decision or not. I personally would think that the standards of the Fourth Amendment should apply to all law enforcement gathering, but that's not the law that we have. But I mean, nonetheless, there is a way to bring in some of that Fourth Amendment protection into FISA and the FISC as kind of a first step. And then as a second step, there is a need to harmonize the law across the United States, for example. There's been a lot of push in both Congress and in federal courts to recognize, these stronger Fourth Amendment protections for, pervasive location surveillance or emails and internet activity and whatnot. And unfortunately, as most things are in Congress, it takes a little bit of time for that, for Congress to kind of deal with things. And so, what we're seeing is state courts and state legislatures step into that void and do some of that work, instead, and whether that's, enacting, state level legislation, or state courts are considering these under their state constitutions. We need to kind of adopt stronger privacy protections overall across the country. But, to see these small states do it is a good first step.
All right. Well, I'd like to switch gears here for a moment. Let's go ahead, though, and drop in our second MCLE passphrase for this episode of This Week in Law. And if you're looking for more information on getting education credit, professional education credit, head on over to the twit.tv wiki at wiki.twit.tv and our show page there, and there's a bunch more information for you. Our second phrase for this show is going to be third-party doctrine. Let's talk about privacy and kids for a bit here. Another issue near and dear to lots of people's hearts. And let's talk about Build-A-Bear, which is something that I've paid attention to in the past, just in my course of when my child was much younger, taking him there and noticing how much information about little kids was being gathered from them at cutesy little kiosks with fun, brightly colored Dr. Seussian keyboards. When you go in and you get your, what do they call it, a birth certificate for the bear that you build at Build-A-Bear, there's a whole lot of information. And this was a few years ago now. I have no idea what the in-store experience is like now, but they were gathering a lot of information that raised my eyebrows at the time. And apparently, Travis, on their website, something similar was going on. Can you bring us up to speed?
Sure. What was going on is on their website, there were really two issues. One was that there was you had to enter your birth date to get onto certain parts of the site. And, they prefer, the best practice is you don't allow them to go back, hit the back button on your browser and just fix that date. You have a cookie in there that remembers that remembers what they entered the first time, so you can't circumvent them. That was apparently turned off, and they had a step like that in place. They just had it turned off for whatever reason, and they got that fixed. The more interesting from a sort of a legal perspective and business law and advising clients is on their homepage, before you had to do age verification, they had the typical thing we see on a lot of websites. Follow us on Twitter, follow us on Facebook, where you could just click on those links and it would take you to those social media platforms. And the issue was Twitter and Facebook, while they have their own sort of age requirements and anti-circumvention procedures in place, if you went through those clicks to get on there, it then allowed the minors who were originally on the Build-A-Bear website to share information on Twitter and LinkedIn without necessarily going through this age verification process. And so the best practice sort of recommendation was that you put those links, the follow us or friend us on Facebook links, after you do the age verification. If you're dealing with a site like Build-A-Bear that quite clearly is aimed at children and therefore is subject to COPA and needs to take better steps to make sure they're not collecting information from minors without the parent verifications and the other requirements under COPA.
Right. Cory Doctorow, with his great way with words, when I wrote about this a couple of years ago, actually it was back in 2008, several years ago, called the practice private information seduction, where, you make it seem like it's fun. How much does my kid know? Do you really know our address? Let's put that in. And, but, in a context that makes it seem like it's very kid friendly, but winds up, as you're describing, Travis, perhaps sharing data with other entities, not the one you expect. How did that work exactly? How is it possible even to be sharing data on Twitter without a Twitter account?
The KRU decision that talked about this, which again is a private organization, sort of a self-regulatory issue dealing with children's privacy. They didn't go into the details exactly on how that was done. It just made it appear that it was sort of an invitation to have that it was Build-A-Bear's website, and that's why they were after Build-A-Bear and not necessarily Twitter. That Build-A-Bear was inviting minors to share personal information about themselves without necessarily taking their own reasonable steps to make sure it was age appropriate. And so they were holding Build-A-Bear responsible in a way and saying you can't just simply rely upon what Twitter does or Pinterest or Facebook. You need to make sure before you send somebody, what is very likely to be a minor, before you send them off to another website, that there's some protection that they're not going to share some of their personal information.
All right. Any thoughts on this, Hanny or Evan?
Well, I kind of laughed when I saw it in the show notes. It's like, man, Denise, have been after Build-A-Bear for years. I remember that.
Well, I kind of let it go after that original thing, but I guess, they're still at it.
So I thought you might have seen some real delight to see that they were getting called out by people other than you, so, but yeah, I mean, my kids are now a little bit too old to be going to Build-A-Bear, but they do, collect a lot of information and it seems especially troublesome because, at that moment for parents, it's stressful. You got your kids, at this crowded mall and, you just want to kind of get out of there as soon as possible. But there's all this information collection. So I thought it was pretty entertaining to see you talk about it.
Yeah, it's a larger issue, obviously, than just Build-A-Bear. They're, kids are living their lives online now. And what I'm heartened by is that they can do that so much without putting in a lot of information. Many times they can enjoy an online experience just by making up a username. Lots of times they don't even have, they're not expected to have an email address under age 13. And they're not expected in many instances to put in a parental email address. And the rest of it is just, left alone. What's your age? What's your address? Et cetera. I don't see a whole lot of that going on. So I'm encouraged by that in general. And it's interesting to see a company get called out for not following that practice. In-app purchases, another hot button issue for parents. I guess in the UK, Travis, this is getting investigated. Whether is it they want to make in-app purchases unavailable or just have more controls around it?
They want to have more controls around it, and it's they're not exactly sure what those rules should look like. They're doing the investigation phase in the UK, dealing with both. The phone manufacturers and the settings that might be on your phones, as well as what settings are being done by the people who make the apps. And so it's a matter, and I've been a victim. It's kind of one of these things I hate to admit, but I've been a victim of this. And
I don't know any parent who has not.
Yes,
you've learned the hard way if you're in the iOS universe that there's a setting buried deep that you can flip if you want to turn off in-app purchases.
Right, and the sad part is $80 later, I did it on my old phone. I just traded in and got this new one, and because of preparing for this show, I have now gone on the new one to make sure the settings are taken care of on this new one. And so it's something that the UK says that it's sort of on the sort of like our version of the Federal Trade Commission. They want to protect the consumers from misleading practices. And by having these apps advertised as free, that's in a way misleading, because yes, you can download it for free and play the really sucky version, or you can download it for free and $80 later you have the coolest avatar in the game. And so it's the misleading aspect of calling these apps free that the UK is really starting to investigate.
And is there any parallel in the United States? Because obviously false advertising is not a good thing here either.
Yeah, I'm not aware of any actions or anything that's been taken against a app manufacturer or even the phone companies just for having these in-app purchases available. Now, obviously, if there was an app out there that was advertised as free, downloaded as free, and then somehow rang up these charges against you to your Apple account or whatever without some type of notification, there would already be some actions. Usually there is a confirm button or something going on, and so there hasn't been actions or statements from the FTC, but that doesn't mean that they're not watching. The FTC's not watching what's going on across the pond and might take some similar actions.
All right, and a final kid-related story. Travis, you wrote this up at eMedia Law, is about kind of the larger issue that we've discussed on the show before, the right to be forgotten, but this specifically aimed at younger people in the form of two bills pending in California that essentially would permit or require an eraser button on social media sites used by teens. Can you tell us about that?
Sure. There's two different bills before the California Senate. One of them would allow the parent to ask for removal of information that was posted by a teenager. Now, there are some under COPA, there's some rules that apply to people under 13. This would broaden that to ages up to 17. Then there's another one that allows similar rights for the actual 17-year-old or 13 to 17-year-old to request that things be removed. What they thought might have been a good idea to post at 2 o'clock in the morning, they can have it removed and require social media websites to remove those things. The interesting part is, it already says in there that social media sites won't be responsible or won't be required to remove, let's say, that picture of your 17-year-old that was posted by somebody else. But if it is something that the 17-year-old actually posted, they would require the social media sites to remove it, and also to have notices in their terms of service, which we all read every time we go on these sites, to say exactly what rights you have to getting these things removed. And sort of the broader picture for a lot of businesses, there was a discussion about, in one of these bills, about advertising certain products like alcohol and smoking and other age issue, not for minors products, that you wouldn't be able to advertise these on sites that allowed 13 to 17-year-olds. So just think of social media marketing, which of course is all the rage for R-rated movies on social media sites, may be seriously affected because technically, if you're not above a certain age, you're not supposed to go in and watch an R-rated movie, and that might be covered by a law like this that says you're not allowed to advertise on social media sites that collect information about people 13 to 17.
Given our whole earlier discussion on this show, is there anything in these laws, Travis, that you've seen that talks about the extent to which this data is erased?
There is. Part of the disclosure requirement says that we will do our best commercial reasonableness efforts to remove this information. But the disclosure requirement would include language that would say something to the effect of, this is no guarantee that it will be taken away from the internet. And it doesn't really go into details about how it might be, requiring disclosures of how it might still be there even though we try to remove it. But as we all know, a screenshot or a grab or a share or something can mean that even if I get it removed from my personal profile, it's still there on the internet and it's still out there for the rest of your life.
Hey, we had a follow-up from Web 0882 in IRC, and I think he or she may be talking about, I'm not sure which app store, but they're pointing out that with respect to in-app purchases and the issue of false advertising, apparently now that free apps with in-app purchases are indicated as such in the App Store. I'm not sure if that's iOS or Android or both, but that's a good thing. Let's end our discussion stories with something related to both PRISM and copyright. Okay, so you have to be a copyright wonk to have the same reaction to this story as I did. But Evan, you tweeted this, and it was my favorite PRISM story of the week. And that is that in those terribly laid out PRISM slides that were released, there is a little logo, the PRISM logo, that looks like, you know, something from Dark Side of the Moon with light going through a prism. And over at the Register, Damon Hart Davis has written that actually this is probably an exact copy of a photograph that his father took and made available online. So not only are these things, you know, causing outrage and dismay in so many ways, they're also copyright infringement.
Yeah, isn't that clever? And it just is the icing on the cake of this story, really. And I mean, I guess it's a little unclear whether there really is infringement, because the website made the photos available, but there were certain preconditions that the photographer, and I don't know whether we can say required or at least requested, you know, that you give attribution, let them know that you're using the photo here. But that doesn't obscure the fact that, wow, look at how the government wants to rip us off, or rip people off, as if the whole idea of what the NSA is doing isn't bad enough. They're also willful copyright infringers as well. And if you follow Normative on Twitter, you know, he was at Normative. He was talking about some. I mean, he's been going off about the NSA all week, and he kind of summarized it in response to me tweeting about this. Is like, now they're in trouble. You know, they're copyright infringers. Yeah. So we ought to sick Prenda law after them. You know, that'll solve the problem for this obvious piracy, this theft. You know, that's
yes.
Let's get them.
That'll do it. No more worries about PRISM. They've now put themselves in the way of the DOJ's copyright infringement enforcement mechanism. So not to worry. All right, let's go on to our tip and resource of the week. Our tip of the week was tipped to me from someone who follows us on Google+. Thank you so much, a tipster, for that. It's an article by Violet Blue over at ZDNet, where she did Ask a Hacker and came up with the top 4 anti-surveillance apps. So if everything we've been discussing today is of a concern to you and you're interested in having a more private relationship with the online world, the 4 apps she and her readers and the hacker in question recommended are Text Secure, which encrypts text messages. Red Phone provides end-to-end encryption for calls, securing conversations so that they cannot be listened to. The Onion browser, which is a browser that encrypts and tunnels web traffic through the Tor Onion router. And Orbot, a proxy app that empowers other apps to use the internet more securely. There are some other things that she points to over there, including, of course, over at EFF, the Surveillance Self-Defense Guide, and particularly its section on what can I do to protect myself. So all kinds of good tips there for a more secure and private online experience. Thanks, Violet and EFF. Hanny, anything in particular that you as an EFF staffer pay attention to in your online life?
because it goes a little bit to the Build-A-Bear thing, but I think people have to be very, very careful with which services they use and how much information they're disclosing to them. And really, when it comes to mobile phones and tablets, we're all installing lots and lots of really fun and cool apps, but we should be very careful as to what information they're accessing, like Temple Run, just picking at random, not picking on them specifically, but just like, Temple Run doesn't need access to my contacts or my location, so just be very careful of that, and, surf the web safely out there, people.
Absolutely. And a couple of resources for you this week. One is if you do want to support the Wyden, et cetera, bipartisan Senate bill that is pending, and otherwise encourage more transparency about government surveillance, head on over to Stop Watching Us, which is at opt-in.stopwatching.us, where you can read a full letter to Congress calling for more transparency about FISA and the Patriot Act. And you can sign the letter and, make your voice heard on these issues. So this is various signatories are involved here, including the ACLU, EFF. You can read the whole list down at the bottom of the site, but definitely folks looking out for freedom and transparency are behind this. So also, I wanted to point you, someone in IRC during the show pointed out that Steve Gibson in episode 408 of Security Now did a whole deconstruction of PRISM. It's called The State of Surveillance, How the NSA's PRISM Program Works. So if anyone can get a handle on that, certainly it's Steve. I haven't watched that yet, but I will. It's obviously a fascinating topic. And then finally, Evan, did I point to the VH1 rock documentary downloaded last week?
Yeah, no, we didn't talk about it last week, but it's in our notes for today. That looks pretty good. Yeah, people should check that out. It's quite nostalgic about the early part of last decade. It's hard. Yeah. It's weird to think that's subject to nostalgia now.
I know, it feels like yesterday to me, but it's all about Sean Fanning and Napster. And for folks who, are too young to remember Levi's ads referring to obscure James Dean movies and others, you might not, have that direct experience of what Napster was like and how it changed everything. And so this VH1 Rock Docs documentary for the movie downloaded. We have a link to the trailer in our discussion points at delicious.com/thisweekinlaw/215. Go check it out. And I'm looking forward to seeing the full movie. And I thought it would be of interest to folks who watch the show too. So this has been so interesting and informative. Thank you so much, Travis, for joining us again.
My pleasure. Anytime.
Anything you want to let us know before we go ahead and sign off? Anything that you're up to these days that would be of interest to the folks watching and listening?
I guess since you've given me the opportunity, I'll plug the blog, emedialaw.com. That's at the bottom. So I try to keep up with the privacy, not necessarily on the big government and big brother side of it so much, as more as how it affects day-to-day business owners and smaller to medium-sized businesses.
Great. Thanks so much for joining us again, Travis. Hanny, great meeting you.
Oh, great meeting you too. I'm very happy to be on the show. I'd love to do it some other time if you'll have me.
Yeah, we'd love to have you back. Before then, I want you to get some sleep and some good nutrition.
We're trying. I've got my lunch ready to go, and I'm going to use my shameless plug. If you do want to follow more information about PRISM, NSA, and the big government privacy issues, make sure you check out EFF.org. There's lots and lots and lots of stuff to read there too.
Right.
But I will definitely be getting some sleep and eating this weekend for sure.
I'm very glad to hear it. Of course, the Deep Links blog at EFF is just an invaluable resource, and Hanny frequently posts there. Hanny, excuse me. And Evan, great as always to chat with you.
Yeah, for sure. A good time. These are interesting days that we're living in, and just been some really, really interesting stories that have come up, issues that have arisen that really give us the opportunity to think hard about these things. And with each day that goes by, and with each new issue that comes up, we recognize that these issues are so important. And especially with this NSA stuff. This invasion of our interests from the government. This is something that what I really hope that here on the show we don't let up on, and more importantly that folks at the EFF and mainstream media and everybody out there. I mean, this affects us all. We don't let up on this, because this is way too important to sweep under the carpet and be like frogs in a pot to all of a sudden realize that the water is boiling after it's too late. So I'm so glad that we have this forum to discuss this stuff, and really enjoyed our conversation today.
Me too. And the Sue, who always reminds me when I forget to drop the MCLE passphrases into the show, is wondering if EFF is on Twitter. Yes, they are indeed. They are at EFF on Twitter. Evan is at Internet Cases. I am D. Howell over there. That's a great way to get in touch with us, to let us know stories that have caught your eye during the week that seem interesting and pertinent to what we discuss on This Week in Law. If you're not a Twitter person, head on over to Facebook or Google+. You can find us there too. And we get a little bit more than 140 characters in those venues, which is nice because some of this stuff requires a little bit more than 140. So find us there too. We love hearing from you. We definitely, I couldn't do the show without all of you giving us things that have caught your eye as important, because they generally are just that. So we really appreciate that. I also wanted to thank, we have a summer intern again this year, Rebecca Klosner, who, like our intern last year, Franklin Graves, is from the great state of Tennessee, or at least she's going to law school there. So she's been a huge help this summer and continues to be in doing our bookings. And I wanted to toss this out to everyone who listens and watches. We are always on the lookout for great people to have on the show. So if you have suggestions, please email me or Evan. I'm Denise at twit.tv. He is Evan at twit.tv. And we'd love to hear from you about who you think would be a great guest. And Rebecca will be more than happy to get you on the calendar. So thanks so much, everyone, for joining us. I've really, really enjoyed this discussion. I've learned a lot today. I hope you have too. And we'll see you next week on This Week in Law.